Today's topic, I will going to deliver a talk on overview of intellectual property right. That is, I will just cover all about what is intellectual property rights, and in the next step, I will going to cover how to file an Indian patent. So I will cover how to file an Indian patent with all the procedure. Okay, online procedure. Uh, so starting with this, I'm showing one slide such that we have everyone will recognize these faces because these are the CEOs of multinational companies, which is famous in worldwide. Why I'm showing this because we Indians have the knowledge better than any other countries. We have very creative and innovative minds and desired minds. But the thing is, our economy is far away from so many other countries. Uh, what may be the reason? Because we are innovative, but we are not restricting our innovativeness so that other will copy. Okay, so we know that it's a complete competitive world. In order to be competitive in this world, innovation is the key. So if at all just innovation is the key, if at all we are innovative is enough? No, we should protect it. We should protect our innovativeness by using intellectual property tools. If at all, if we only have innovativeness and if we don't protect our innovativeness, definitely someone will going to copy and they will going to do our works. So this is 21st century. So as I told you, innovative is the key in order to survive in the competitive world. So the 21st century belongs to the knowledge economy, where previously we had agricultural economy and industrial economy, where capital machinery management is more than enough. But now today, 21st century belongs to the knowledge economy, where innovativeness or innovations are very, very, very important. So if these innovations, it will be created, but it should be protected. So how to protect the innovativeness is through intellectual property rights. So we'll see what is basically the intellectual property. So intellectual property means it's a product of the mind and human intellect. Whatever you think, it may be any inventions, new inventions. It may be your literary and artistic works. It may be music. It may be your new design of a product. Uh, and it may be the symbols what you have used to start your startup companies, the names, the images which is used in the commerce, and also the culture and also the heritage of the region is also can be protected under intellectual property. So intellectual property is just a connection between the mind and human intellect. Whatever we do, it will be then innovations, it may be in songs or anything, we have to protect it. That's nothing but an intellectual property. So why this intellectual property we have to do, or why this intellectual property is important? Because as I told you with the first slide, even so many MNC companies, we have so many CEOs, but we are economically weak. Why? Because we are not protecting our intellectual property. If the intellectual property is protected, then we can easily convert that into commercialization. So the intellectual properties, that is nothing but ideas, inventions, creations, have commercial values. So if we convert our innovations, ideas and creations into commercial value, our country economy will grow. So the intellectual property is very important for any country. So how this intellectual property is protected? The intellectual property is protected by so many ways: through patents, through trademarks, through geographical indications, through industrial design, through trade secrets, through IC layout designs, and also through copyright. So these are all the tools which we can use in order to protect our intellectual property. So we'll see one by one what is patent. I will just cover a brief thing and I will cover only the procedure to file a patent. So we'll go one by one. So before that, if I given an example, for example, everyone will be seeing this example, a Rubik's Cube. If I ask, if I give a Rubik's Cube, whether it was a patentable, or whether it can be protected under a trademark, or whether it can be copyrighted, because these are all the intellectual property tools. So if I ask whether it is patentable, whether it can be protected under trademark, whether it can be protected under copyright, or whether it can be protected under the design, or whether it can be protected under trade secret, what will be the answer? Okay. Someone can say that it can be patentable, someone will say that it is can be protected under trademark, like that. So the actual thing is, this will come under two things. This product can be patentable, and also the company which they are producing, that company name will come under the trademark, but it cannot be copyrighted, and it cannot be secured under trade secret, or it cannot be secured under design. So we have to know each thing. What do you mean by patent? What do you mean by copyrights? And what do you mean by trademark? Each and everything. Okay. So I have shown you the Rubik's cube. So this Rubik's cube actually patented by an Hungarian sculptor and professor. His name is Erno Rubik in 1974. Okay, but actually the patent was granted in 1983 and it was expired on the year 2000. So it has got the patent, and also the company that's named as Rubik's Brand Limited, it is registered under the Trademark Act. So this example has comes under Patent Act and also the Trademark Act, but it will not come under copyright or trade secret. So we have to know which product will come under copyright, which product will come under patent, like that. So we'll see one by one. So what is patent? So a patent is just an exclusive right granted for an invention, such that others it will exclude others making your product. Means it will going to exclude someone to copy the whatever the invention you have done. So a patent is an exclusive right granted for an invention, a product, or it may be processes that provides a new way of doing something. Okay. And its duration is 20 years. After 20 years, if it expires, renewal is not possible. Okay, renewal is not possible. And also you have to know that if I file a patent in India, it is valid for only in India. It is not valid in US. So if at all that product is used in many countries, you have to file the patent in each countries where this product should be used. That is the thing. Okay, so the patent is a local region wise, means we have, in order to file, if you file the patent in India, it's valid only in India. So if you want to the patent royalties, if you get in other countries, you have to file that patent in other countries also. In India, we have 5 patent offices. One is located in Chennai, another is Kolkata, Delhi, and also Mumbai. Four locations, patent locations. Trademark is 5 locations. So 4 locations it is in India, or Chennai, Kolkata, Delhi, and Mumbai. Previously, especially in our state, Karnataka, we need to go for Chennai in order to file in each patent. But now we have the possibility of filing a patent through online. So that procedure I will going to explain you in the next concept. So the importance of patent is, for example, you would have seen so many examples such that the Apple company has filed a case against the Samsung such that they have copied some other concept like that, right? So even the Apple company also has so many cases. For example, Qualcomm. Qualcomm is very small company, a very small company. They filed a case against the Apple because Apple company has imposed some technical parameter in reducing the battery consumption. So that reducing battery consumption technology patent was filed by Qualcomm, but unknowingly the Apple has been adopted the technology, and the Qualcomm has filed a case against them, and by calculating how many product has been produced through Apple, the court has sued them with $31 million. So very small company like Qualcomm has benefited that huge amount just by filing a patent. So we can come to know what is the necessity of filing a patent, or if you have written a book, how to protect under copyright. So you can know the importance of the intellectual property. So this is about the patent. We will come again to the patent in the next slides. Okay. And what are the things can be patented? We can patent anything which is innovation. So I'm showing just a photograph of Michael Jackson. So many of them has been seen this video, the lean step of the Michael Jackson. If we have to try this, definitely we're going to fall because it is against the gravity. So Michael Jackson also has so many patents. So one of the example I'm showing here just to showcase you that what are the things, anything can be patented. Okay. So he has patented his shoes such that if you wear that, he has that technology, he can lean up to 45 degree. So this is one of the shoe that he has patented. So patented can be a number of things we can patent, but we have to know what can be patented and what would not be patented. As I told you, the patent was the reason is it should be filed with a region wise, and it's not that Indian should file only on Indian, and the Indians, US people should file only in US. Anyone can file the patent in any country. For example, if you search in Google for a topic as top 10 US patent holders, we will find in the 7th list that is Gurtej Sanju, who is an Indian, and he has 7 highest number of patents. Within 10 he will come. That is 1,346 number of patents he has in US. So anyone can file a patent on any country depending on the product where it will be used. For example, a product which will be very less used in India. If I file a patent, it's no use because that royalties will not get the charges, whatever we use to search a novelty search and other things and to file a patent. But that product, if it is used in the US, largely we have to file the patent in that US. So Gurtej Sandhu is an Indian who has a lot number of US patents. And as I told you, we have to know what should be patented and what should not be patented. I have given just an example. Dr. Mashalkar is an eminent scientist, has filed a case in US patent such that before US patent office has granted the patent for turmeric, neem and basmati rice. But Dr. Mashalkar has filed a case against the US patent office itself such that you should not they should not grant the patent on this because in the traditional knowledge of India, we know what is the usage of turmeric for so many advantages, and neem as well as basmati rice. And he won the case, and so many revolution has taken place in filing a patent such that what should be patented and what should not be patented. If at all it is previously used in traditional things, they should not file a patent. Instead of that, we can file under geographical indications, GIs. Okay. So this is about the patent. We will come in detail how to file a patent and about novelty research in the end of this presentation. And as we know, patent is for a product. But if we design something, it may be ornament, it may be textile, it may be dress, anything. So if I will design new things, someone will copy easily. So we can protect that also through industrial design. For example, Apple phone shape. The shape of the Apple phone you cannot find in any other phones. Why? Because that design has been patented. And if you see Coca-Cola bottle, so the Coca-Cola bottle design is also patented. And this cannot be used from many other companies because they are all restricted under industrial design. So an industrial design refers to any ornamental or aesthetic aspects of an article. And this is for 10 years duration, but they have to renew for 5 years only. Means for 10 years, first 10 years they will going to give. For example, if I file a industrial design patent for at the year 2020, it will be given for up to 2030. and it can be renewed for 5 years, but patent only for 20 years, it cannot be renewed. And this is also very important. You can see one of the case, which is I think everyone has seen the BlackBerry phone. So whatever the keypad they use, it is a unique design and they have patent. So one of the company called Typo, they have copied the design of BlackBerry. So the BlackBerry sued a case on them and they got 8,60,000 US dollars. So the industrial design also can be patented. Sorry, it can be protected under intellectual property rights. And also the integrated circuits, whatever you design, that can also be protected under the law. But the thing is that circuit cannot be patented. So you can see the difference between patent, you can see the difference between the industrial design, and it can be seen the difference between the layout design of integrated circuits. So the layout design of integrated circuits can also be protected under intellectual property rights. Its duration is for 10 years and it cannot be renewed after the 10 years. And whatever, if you start a startup or if you have a companies, the trademarks can also be registered. So a trademark is nothing but a distinctive sign that identifies certain goods or services produced or provided by an individual or company. For example, we will be seeing, right, Pepsi, Coca-Cola, Toyota, Tata, like that, their trademarks will be seen, right? And also you can see the two symbols in the DVD. Have given the symbol TM that indicates trademark. In the Coca-Cola, they have indicated in the circle R. So what is the difference between that R and TM is R indicates it is registered. The brand is already registered and they have given this certificate of trademark. But some companies, they will going to indicate TM. What is the TM indicates is they have filed for the trademark and they have not still registered. So TM indicates for they have already filed, but they have not got the certificate still. So once they have filed, no one can file the same design. Okay. So, and also this is unlimited time, means if at all I have started a brand like Coca-Cola, it can be for unlimited time. But the thing is, for every 10 years, we have to apply for renewal for that trademark. So it will going to protect the unique name, the design, the logo, as well as the symbol, the even colors will not come. Means if at all someone will write the same thing Coca-Cola and he will copy with the blue color. Okay. So the symbols will also be protected and color is also protected under the Trademark Act. So even this as one of the case we can easily highlight that is first, I think everyone has know Maza drink, that will mango juice. Actually, that is was first started from the company Parle, that is from Distillery. Distillery, whatever the water we are getting, same company Distillery, they have produced the Maza, and then they have sold that for the Coca-Cola. But what they were doing is they were after even selling the Maza brand to the Coca-Cola, they were not selling they were not doing the sales in India, but the distillery company was doing the sales in Turkey, and Coca-Cola company filed a case on them such that they are doing the sales on Turkey. And the Indian judiciary, they are given what the distillery company they have claimed is they have given permission to sales only in India, and but the company but the court has been decided such that once you sold the trademark, you cannot sell the same with the same logo, same other things in the next country also. So we have to protect everything with respect to the symbols and the color and other things. And the copyright, this is very useful for our faculty fraternity. Of whatever you write a books or if you write a program, computer program, that also can be protected under the copyrights. A copyright is nothing but a legal means of protection of author's work. It may be literary, it may be artistic works, it may be music, it may be computer programs, sound recordings, films, etc. The duration will be up to lifetime of the author and plus 60 years. So lifetime of author plus 60 years. So even after his death, up to the extra 60 years, their family can enjoy the benefits of the copyright acts. Yes, recently, we can observe one of the case of Ilayaraja. That is, he has won a case such that he has the moral rights over 4,500 songs which is composed by him. Okay, so that is the power of the Copyrights Act. And this is very beautiful. That is geographical indication. We know so many. If I go to the Karnataka, we say Mysore silk, and if I go for Tamil Nadu, we'll say Salem fabric or Kanchipuram silk, Tanjavur paintings like that, and Tiptur coconut like that. So these are all and Chanpatna toys. These are all comes under geographical indications where we can protect our heritage and culture by filing the geographical indication. Means someone, for example, we are doing Chenpotna toys here, and we can sell that with a brand of Chenpotna toys. But someone who is doing other than that place, if they call Chenpotna toys, these people can file the case against them because they have their geographical indication. No one can use the name as Chandapotna toys and they can sell the product. So this can also be protected, and also we can see that Karnataka is in the place of number one. That is in the India, Karnataka is the number one, which have filed more number of geographical indications, where we have protected so many things from Mysore silk to Chenpotna toys, and we have so many more with the turmeric and other things, which will be protected under geographical indication. And even in international airport, we have one selling unit such that they were selling the geographical indication items through central government. So these are all the overview of the intellectual property. Yeah.
Somebody started presenting. Sorry, it is interrupted. Your video, I mean, it's not visible.
Okay. Shall I share again?
Yeah, probably. Yeah. Anil Kumar, please do not stop presenting. Yeah, now it's visible.
Yeah. Okay. So this is about the copyrights and geographical indication. So we come across all the things of intellectual property rights, that is patent for a product, and the industrial design also can be protected, and the integrated circuits also can be protected under the law. Layout design of integrated circuits, trademarks can be protected, your books, songs, computer programs can be protected, and the geographical indications, whatever our heritage and culture can also be protected with the different time limits. Geographical indication is unlimited, but again we have to file for every 10 years for the renewal, and also we have to prove the quality also. There are means even we have famous for Chanpatna toys, we cannot easily get the geographical indication. Once we prove that our quality of Channapatna toys with respect to other toys, then only they will going to grant the geographical indication. It is also very difficult task to get the geographical indication. So these are all the overview of the intellectual property things. And these are all the present legal systems. Means the patents are protected under the Patent Act 1970. The industrial design is protected under Design Act 2000. We can go through each and everything, how it is protected, what should be patented, what will come under design, like that. Each and every parameter is discussed under these acts. Trademarks is a new Trademark Act 1999, copyrights 1957. And the layout design of integrated circuits will come under the semiconductor integrated circuit layout, which is recent, that is 20 years. From 20 years actually it was there. Geographical indications will come under Act 1999, and also the plant variety protection comes under Act 2001. So these are all the present legal system for different intellectual property things. So I have given just overview what are the things which will come under the intellectual property. Now I will going to cover only with respect to the patent, how to file a patent and how to do the search. So let us see the how to. I'm now just concentrating on the patent filing procedure. That too, especially in India, as I told you, each country has their own different legal acts. According to that, we have to, and the format will be different, and the fee structure will be different. So according to them, we have to file. Now I am discussing only with respect to patent procedure in India, patenting procedure in India. If you have to file through hard copies, we have to visit the centers in Chennai, Kolkata, Delhi, or Mumbai, whichever which is convenient. But even though we can file through online without going to any institution. That is, first step involves filling an application with provisional or complete specification to claim the priority. This is the first step. So first we have to file an application with provisional and complete specification. So I will go show you in the next slide what do you mean by either a provisional specification or complete specification. And the second step involves the after filing, it will be published in the Indian Patent Journal. So the Indian Journal Office has their own journal, Indian Patent Office. They will going to publish their publication within 18 months. So then the after publication, the request for examination to be made within 48 months. This request can be done by the people who have filed a patent, or it can be by from other person also. That will I will going to tell in detail. Then after filing, the experts in the Indian Patent Journal Office, they will do examination. It will take time, maybe 6 months. After examination, they will going to give the examination report. If at all there is any objections, it will be communicated to the applicant. So after receiving the objections and other answers from the participant, that is reply from of the examination report should be submitted by the applicant with the necessary changes. Then either they will going to grant or reject the application. So this is the brief procedure to in order to file a patent in India. So what is the first step is, in order to file an application, what are the things is necessary? The first thing, we have to prepare with the whatever the title of invention we have. We have to we have to give an abstract and the field of invention in which we have done, in which field we are doing the invention, and background and prior art. So that way we're going to show in the novelty search and other things. So we have to do so many novelty search and other searches in order such that no one has already filed this patent, or whenever you file a patent, this should not be published either in media. For example, if you do some innovation and if you publish in the media, then you cannot file a patent, or else the product already it's in manufacturing and it is using by someone and you cannot file a patent. So it should be very novel. It should be very novel. So we have to do background and prior art and objects of the invention, means objectives of the invention, and complete summary with complete drawings and with the descriptions, and the detailed description of the preferred embodiments, means what we are claiming and other things, and also number of claims. So what claims you are doing. For example, we filed a patent on the metallurgical aspects of some dye. So we have to say what are the things we are claiming. For example, let us think I am filing a patent on bottle. Let us think bottle is just used to fill the water. Okay, so that is the one claim. Means claim means on what things we are claiming. If at all the same type of relative product is already patented, but we have done so many changes, we are not little changes, so many changes. So for example, the mobile has so many applications. So in one of the application, if we are filing a patent, we have to indicate that claim, and we should not claim other things which is already claimed by the some other peoples. So that is very, very important point in the filing a patent. And detailed drawings on the last sheet. So this should be prepared. For example, how we prepare a journal or an article, same way we have to make an arrangement of this consecutive order from the title of invention to the drawings in a proper order. Then only we can go for the filing and applications. That is the first step. So once we prepare with this, we have a website that is ipindia.nic.in. It's an official website of Intellectual Property India. In this, we can go for comprehensive e-filing of an Indian patent. But in order to file this, uh, so if you go for the comprehensive e-filing, you will go to the another screen. It will ask what are the things you have to do. So we can go for filing an e-patent. So or e-filing patents. Then it will go to the login. But in order to log in, we cannot log into this website without having the digital signature. So we should have the digital signature either individually also we can have or through institution also. So once we have the digital signature, we can easily log in with digital signature and the password. So then it will go to the website inside web. It will allow us to log in inside the e-filing portal. Here we have to be very careful with the selection of the forms, different types of forms. Different types of forms are there. Means as we know, either I can file at the beginning level, as I told you, the first step is itself is provisional or complete specifications. We can file either provisional, means still we have started and we have 50% as the work is finished. So we have scare that someone will going to file. So we're going to file the provisional, or else I have already completed the research and I have a product or process such that I'm filing a complete product itself. So there are two different things. Either I can file a provisional or I can file a complete product. So depending on that, we have to select the form. And also in that we have so many different types of forms. Form 1 for applying of new patent, that is for the first time. Or if you have any, already you have filed a provisional patent and you have to incorporate the complete patent, again we have to select the another form. So depending on the type, we have to select it. So then it will going to ask all the type of the things what we have prepared in the first. As I told you, the title of the invention, the number of claims, drawings, etc. The same thing we have to copy paste here. That's all. Okay. Filing an application is very easy, but the preparation behind the filing a patent is more time it will going to involve. And we have to give what is the abstract, number of drawings, number of pages, and number of clients, all the details. So once we fill all the specifications and other things, and title of the invention, and if we have inventors, inventor may be a single person or in a group 3 to 4 person. So individually with their address, email ID, telephone number, everything we have to place for each inventor, and we have to agree all the terms and conditions of the IP, Intellectual Property Rights India. And if we upload it, it will come. Okay, but the thing is, then we have to pay the fees. For the paying the fees also, we have different forms. So we have to select the form and we have to file it. So first step is just to, main thing is we have to prepare the content. How we write a journal, in the same way we have to do lots of research. In doing the literature survey for publication is very easy compared to a patent, because sometimes some data may be available through journals. Sometimes it may be published as a product somewhere and they have not filed a patent. Sometimes they have filed a patent in any one of the countries. So we have to search each and everything before filing a patent. Otherwise, we will lose our time and money. And also, someone can file a case against us also, against us. Okay. So we should be very careful in preparation of all these documents. Filing is very easy, but the documentation is very crucial step. And we have so many agencies which will work under the same thing, where they will going to do literature survey, like whether they have filed a patent anywhere in any country or already the product is existing, like that. So the first step is filing an applications. So once the filing of application is done, the publication of application will be made. Means as we apply a journal in a some whether we have to apply an article in a journal, they will going to publish after scrutiny. But here also same thing. Once we apply, they will going to publish. So the publication will be done after 18 months of applying a patent. But we have the possibility of less time, means we need not to wait up to 18 months if you pay the extra fees for early publications. So the early publication is also possible, uh, but the thing is charges will apply. So how it will going to show? I am showing it screenshot of one of the published file, means they will going to give the patent application number and the date of filing the application, publication date, etc., with all the applicant's name, complete abstract, and number of claims, everything. Why they will going to publish this? Because if at all some company, for example, they are already filed or any other processes, they can ask for the examination of this. Okay. So they will, each and every patent as well as the engineering design will be published after 18 months of the publication, and also early publication is also possible by paying the extra fees. So these are all some examples. See, the design, industrial designs also will be published under design number, the class, and etc. You can see, as I told you, industrial design means not only the product of the automobile or aircraft or any machineries, even the garments also can be protected under the industrial design, and even ornaments design also can be protected. So once it is published, the third step is for request for examinations. So once we file a patent, within 48 months, we can request for examination. Either the inventors can apply for the examination, or someone else who is interested such that this innovation is done by some other company or anything like that. They can also, the third person can also file a examination application. So again, in order to for examination, we will use Form 18, and we have certain procedure for that, and pay the fees for again for the examination, and we have to request it. So once the examination request has been raised, so the application will be done examination by the team of experts. Then they will going to give you the brief report, what are the things they require the information. If suppose that patent has already been filed or other things, they will straight away reject the patent or industrial design. If at all they need some information and other things, they will going to give you the report, and they will again take you the reply for those questionnaires which is raised by the examiners. Then the examination, once they got the reply for their examination or objections, they will going to study again. If at all everything is okay, they will going to grant the patent, or they will going to reject it. So these are the some certificates where the patent office will give the patents from the Indian government. So these are the steps which is required for filing a patent. But as I told you, the first step is very, very crucial. That is the collecting of information, doing the prior art search, everything. As we do literature survey, same way we have to do the patent search. So what are the different patent search are there is novelty search. The thing is, it should be very new, means whether it can be patentable or not. That is, in order to file a patent, it should be very novel, and it should be non-obvious, and it should have the industrial application. Then only we can file a patent. Then we have to do novelty search, means whether they have not done or anything like that, we have to search. And state of art. State of art means it will going to give a complete overview of advancement in the specific field. For example, if you are doing some in electronics, means that state of art search will be done only on the specific field. Then we have the invalidity search, that is to find out a patent whether it is valid or not. A validity search is the thing, but it compares a patent with the pre-existing patents. The thing is, if at all we do only small changes and if you file a patent, then it will become invalid. So if the newer patent contains an invention that is too similar to one of the previous one, so the newer patent become invalid. Means if you do only very small changes to the already existing one and you are failing a patent, then it is invalid. Then freedom to operate search, that is nothing but infringement analysis. It is also known as infringement analysis, or also called as clearance search. This is done to check whether any product or process utilized by an entity, that is it's not infringing on any line of patent line. That is it is used to ascertain that there is freedom to operate and invention, okay, in a particular jurisdiction from a legal point of view. That is nothing but the freedom to operate search. Like that, we have a landscape search, which gives the comprehensive search for patents in a given technical discipline. Assignment search means someone has already filed a patent, but he has transferred all the rights to the other companies. So if at all that thing has happened, that type of search also we have to do. So I'll not go in detail of each. Uh, in order to do these searches, different types of search, we need to know first problem definition. What type of research we have done. So we have to understand the inventions and the problem statement or purpose of search. Then we used to get the keywords in order to search. So the search in a search string, depending on the purpose of search formulate, a search string, that is nothing but keywords in order to search in a broad data. Okay. So once we keep on searching, we will going to have so much of information, abundant number of informations. So we have to read the abstract, the problem solved, and also number of the whatever the claims they have done by the other patents. Then by reading, we can narrow down the search, and then we can easily refine to the specific problem. Because if we keep on giving the keywords, we are going to get number of literature things. So we have to read abstract and the claims and other parameters such that it will be narrowed down, and then we will going to collect only the information which is necessary to our inventions, and we have to file. And also very important thing, we have to see the drawings also. Okay. So this is about, this is very important steps before filing a patent. So we have many tools to search these things, novelty search and other things. For example, we have a site called Espacent, which is of runs by European Patent Office search tool, and we have a site called WIPO, that is consists of World Intellectual Property Organization, and we have Google Patents through Google search, and we have a tool called USPTO, that is United States Patent and Trademark Office, and INPAS is the website which gives the complete Indian patent informations, and so many other countries also their own patent database. So before filing a patent, we have to search it. Okay, these are some of the screenshot how to search. For example, Espacent is the website. So if I search thermal management system of battery, so we are going to get n number of results. So based on that, we are going to keep on filtering each and every parameters. Okay. So this is about our presentation.